So you discover that you need to call an expert for your trial. Rule 36 of the Uniform Rules of Court governs the procedural management of those circumstances. Remember, expert evidence is exceptional because it's based on opinion rather than fact. The expert is not there to fight your case. The expert is there to assist the court with their expertise and their opinion based thereon. Let's assume that a party is required to undergo a physical or a mental examination. That would be governed by Rule 36.8. And once that examination has taken place, a report is required to be provided within 2 months. So you want to set the scene for your expert coming to court. What do you do? Well, after the close of pleadings, within 30 days if you're plaintiff, within 60 days if you're defendant, you notify the other party in terms of Rule 36.9a that you will be calling an expert, the name of that expert, and what that expert's going to come and testify about, an orthopedic surgeon, for example. This is how we do not do trial by ambush. Like I said in my teaser, experts don't just walk into court. There's preparation that goes into that. Right. Now, after you've given notice that you're going to call an expert, Rule 36.9b requires you to file an expert summary. Now, an expert summary is not the full expert's report that may have been provided to you by your expert. It is a procedural matter, not substantive, as is the report. In that expert summary, which must be prepared by the expert, by the way, there would be the reasons, the data, the conclusions for the opinion, the academic qualifications. So in other words, that summary is going to give a summary of what the expert is going to testify about. It is required in terms of the rules. 90 days from close of pleadings by the plaintiff and 120 days by the defendant. Beyond Rule 36.9, there is Rule 36.9a, which plays a very important role in the litigation landscape, and that is the joint minutes of the experts. Not only can this curtail the length of the trial, but it is extremely useful in saving costs and making sure that only the relevant portions are before court. Naturally, it assists the court in arriving at a decision. The summaries and the expert joint minutes should be filed before the first case flow management meeting. That is the ideal situation. Now, beyond that, of course, if there are plans and diagrams, etc., that need to be filed, that would be done in terms of Rule 36.10. It's very important that there's proper trial preparation in terms of the rules, and parties are encouraged to read Rule 36 thoroughly and to comply with it, lest they find themselves in a position where their experts cannot properly be before court. If you would like a copy of the note pack upon which I have based today's discussion, then you can access that by commenting the word expert in the comments and by emailing that same word expert to adjourn4t@gmail.com. It's been such a pleasure to share this pause with you today. Remember, your voice matters. So don't forget to like, subscribe, and tap the bell for the next tea adjournment.